by now you desperately need. But you can continue with that. And once you do, all of this can be revisited and retooled.
Oh, so we can change the zoning, let them in, and then rewrite our zoning to where they're grandfathered.
You can't do that now.
That's convenient.
If you were going to pick up a year ago, more than a year ago, you had voted to seek proposals from planners, and you did, to do a whole comprehensive rezoning.
That's pretty much what he said. No, you could.
So do I want to say that you could, come up with
Rewrite the zoning.
temporary here, maybe not. It's not my place to say, but
So we just slip one in, not letting the other. That's good.
that's been in the works for well over a year.
My son Jeff said, wait till I catch him alone.
What do you want to say about this?
You guys got working?
Just keep the talk down a little, please, folks, right on our.
We're bored with it.
609.1C. We started talking earlier about what that says, and you have it written in front of you. I provided to you what the law says you need to look at. Consider the curative amendments that have been given you, the plans and explanatory materials submitted by the landowner. And in addition to the record, in addition to the exhibits, in addition to the public comment, in addition to the legal argument made by counsel, and in addition to the advice given you by the solicitor. But it also, last but not least, you're to look at these factors. 1, 2, 3, 4. Yes, there's 5, but one of them doesn't apply because it only applies to residential. So you're looking at 1.
Eliminate number 2.
Yeah, eliminate number 2. I already have NA for you. So 1, 3, 4, 5.
A couple of gas would nest. Good. We need some.
Well,
That's
the
why
law,
he
let me
isn't here.
further,
He's scared.
in my memo, Lorraine has it.
I do.
Oh, that, I can share Pat's with them. Another section, 916.1C1, says that the information that had been submitted at the hearing shall not be required to meet the standards prescribed for preliminary, tentative, or final approval, or for the issuance of a permit for this project, so long as reasonable notice of the proposed use or development was submitted and a sufficient basis exists for evaluating the challenged ordinance or map in light thereof. That's section 916.1C1. You've got to understand that in reading these factors. So are you all suddenly to become geologists and engineers and, no, you're not.
Neither are
You
you.
can basically take what you heard, and what you know the area, know the town, and know
the town.
whether you could, consider these things. Remember that this is not approval. There's a long road to go for that, all that other stuff will come up, and if you get to a conditional use hearing, it'll come up in
Oh, yeah, no.
a
Just get the
DEP
proof.
permitting issue, it'll come up in so many other places, but that's not for tonight.
Yeah, if you were to do an environmental impact study, Rick, that would cover that.
Oh, a lot of that. Which is required, as I keep saying over and over, that is required by your ordinance. And if this plan ever gets to a conditional use hearing, that, you got some really, one thing I will say about the ordinance, there's some really good protection in there for the borough on environmental impact and assessment. A lot of people have asked, I've received correspondence asking, how come I've never advised that? Well, because it's not the time to do that. Folks need to understand that that process hasn't even hit us yet. You don't do that in connection with the curative amendment process, you do that in connection with the conditional use, and it is definitely coming. The ordinance requires it.
What's costly to do an environmental impact study, I don't think you do that before you tell.
No,
some type of
put the
curative
cart before the horse.
Yeah.
And we don't do it.
Really? The
applicant
DEP
has
is
to-
doing it?
They have to submit it to you. Again, I'm not, that's getting way out of what we're here to talk about. I'm just saying as an FYI.
So even though the curative amendment has to be fixed, and we have to go up with a cure, that in no way precludes that this plant is a done deal.
No, I said that in my legal memorandum. Now, obviously, there'll be a lot of people who are not gonna, they're gonna disagree with that, because many believe, because I've seen the arguments, I've heard the comments, that once you do this, you're basically paving the way. Does it clear a hurdle? Yeah, it clears a big hurdle, but they're just beginning the approval process. This isn't approval. They didn't start the approval process yet, not with the borough.
Change zoning
Well,
for them,
I
they're
take that
essentially
back.
approving
They
it.
actually did start it in the
Sure they
sense
did.
that
They
they
voted.
submitted a land development plan, which was stalled in its tracks once this hit. So yes, I apologize. They did start the approval process by virtue of the land development, but they have not really submitted a request for a conditional use. Not that I can remember. It's been so long. I've been through so much, I can't remember. I don't think they did.
So they have to do the land development.
So, oh, they have to, yeah, they have to go back to, if you go back to my memorandum of solicitor's legal opinion and advice, let me just hit briefly on it. Here's what's, bless you. There's a pending land development plan before Jessup Planning, which has to be revisited and likely needs to be amended, because I think when we left off, we were talking about water cooled versus air cooled.
Oh, you're
So
gonna
that
let
has
them
to be
change it because
revisited.
DEP
So I
will
will,
change the plans?
2, has to go back to Lackawanna County Regional Planning Commission for comments. 3, DEP, all permitting required by DEP and/or federal EPA regulations.
Which is a
4,
done deal.
submission and review to council the conditional use application by Lackawanna Energy. And under that, I point out that there are strong tools the borough can rely on in considering all the criteria that's listed under conditional uses that you must look at, and they're pretty exact now. And most importantly, an environmental assessment, which is like, takes up 4 or 5 pages alone in the ordinance, so my point is that
Wow, so that's
it's
stronger
a
than a
pretty
DEP
involved
assessment?
process that goes into a lot of detail as to what's behind it. And it'll be whatever it is. I'll let you get through all that. So let's talk
Make your
about
lives
material.
easier, cure the M2, and be done with it.
You have scheduled for next week, Thursday, it's already advertised, a vote on the cure.
No. Yeah, we can just figure out how to rewrite our zoning in one session.
I'll need to further digest this.
Good. Something easy. You should be able to figure it out in 4 hours.
My thoughts,
We know where it starts. Put it up on the map. We got
and all
this.
those things and those factors, are, I think the answers are all there.
I think it's good. And now everybody looks over Randy. Come on, help us. Help us.
So, in reference to the owner of land in name 2, it would be immaterial if we weren't going to procure that piece of land, because he can't market that right now because of the 2,000-foot restrictions existing development. So as long as you don't change the 2,000-foot restriction over on the proposed site, this gentleman doesn't have to be, his situation doesn't change. Correct? You follow?
I apologize to you.
That's okay. That's all right.
Why don't you just say names?
Council chooses not to. See, read section 2. Condition for the M2 heavy manufacturing districts, Schedule 3 of Article 3.300 is hereby amended to delete electric power
If
generating.
you were to, I said earlier when you asked the question, if you're gonna put it in the M1A, you have to delete it from the M2. Put it back the way it was intended.
I know. Why don't I just verify that that gentleman or that owner is not affected in any
obviously, can't. It's relevant, because I don't think the records are reasonable. Right.
I'm like worried about this one person being able to market the land. Wonder who that is. I guess so. Because he keeps going back to that person being able to market that land. Why don't you say who it is?
Can you actually vote before landowners, surrounding landowners are made aware of the change?
They're on notice.
They are on notice?
Again, I don't know which landowners you're referring to, and I don't know if it's really a record, but I don't. they're-
We're changing the zoning in the end too. I know it doesn't directly affect him because he can't do it now, but if somebody owns land and change the zoning there.
Again, I don't know who we're referring to, and I don't know if even it's a record, and I don't know why. I'm not trying to, I'm just trying to, because I still don't follow, but.
So now we're changing, we're deleting that from your
Howard, can I, if I can.
Let him add another. Debate on why they should do it on
I'm
that.
concerned with a particular property owner in the M2 who may be marketing his property for a power plant.
Well, he can't market it for a power plant.
Can't,
It's not
as of
2,000
right
feet
now,
from
you can't
existing
put one
development. I understand that. I understand that.
There's a 2,000-foot restriction in all directions from existing development. There's no way it could go there.
If
You've
you're
already
changing
decided.
somebody's zoning in any way, process, correct?
I'm sorry?
If you're changing somebody's zoning in any way,
No, we're not changing anybody's zone.
Yeah, you are.
eliminating power plants.
It's of no consequence because he couldn't build one there anyway. Nobody could. That's already been determined by you. You're not doing anything to it. There's no further design or no further.
Because we allow it elsewhere, and now they can't say it's exclusionary.
And the landowners in the M1A would be Slipco,
And they allow it.
correct? Going by the power plant. You're changing the M1A to include electric power generator plants.
Yes, I believe Slipco's covenant is prohibited anyway to run with their land, but then that's where the 2,000-foot restriction from existing development comes in, which protects a lot of this existing Slipco development, and then if you were to put in another,
But if you were to continue your business park, you wouldn't be 2,000 feet from the existing plant. They wouldn't know.
well, they can.
But
They have principal permitted uses that they put in there usually. The restriction applies to conditional uses. And a large chunk of a big chunk of Slipco is S1. And the remainder of the M1A of Slipco is already developed and either taken or, not that that matters, but it's, you know, multi-million-dollar buildings there, so it's developed and it would not even accommodate certain uses. Not to mention, if you put the restriction in, it wouldn't even be. Like, for example, the S1 is so in close proximity. On both sides, both on the 247 side and on the back end, where Team D is.
Right. Right.
Beautiful view from the office. Three of them just sit there. Nothing.
You ask Rick if that is
Or S1.
And when I,
This is M1A up above the S1 piece.
what I just saw in point two of the yellow,
Right here.
yeah,
This is M1A right here. Right here. All this.
yes.
Here.
On there, on the aerial map. It doesn't show, nothing of record shows that. You slip those, slip those. No, I don't. No, there's nothing of record that would tell me that.
Uses the record. Isn't the record?
Best I can do, Joe, is this one exhibit that shows the distances as 13 feet. The brown is like, you could say, the yellow folks. By the way, here, this is our disregard that. The pink kids, yeah, only the pink kids. Technically, my, yeah, the pink. Yeah, the pink. Well, honestly, I should have went up. Yeah, you're right, I should have went up to the black line.
With the pink.
Yeah, it was pink.
But then they decided that they didn't need it.
If I recall the testimony, originally this was the original parcel. And this was added, I recall the testimony. They bought that, that was a cinema land, they bought that as a laydown area. That's why they included that extra area. That's the laydown area. That's the cinema land. Remember that was, there was, the objectors put up the deeds on the record. Cinema land. On the, right by the cul-de-sac. To the left, yeah. Looking up the mountain, Joe, to the left. Yeah. That's the cinema land, I'll call it, that they have.
Yeah, wrap it up. You guys know what to do.
Yeah. Good luck voting on that next. She's tired. She wants to go home.
Let's wrap this up. Come on. Let's move it along.
I'll give you.
Oh, he's going to give us a briefing again?
All right.
That's it. Just go home.
So, draft something, you put in delete from the M2, add to the M1, southeasterly side vacation, 2,000-foot restriction from any other plan.
He just told them what to do.
That problem, that error.
Told them what to draft up.
With the 1990 reference to the 91,
The solicitor